Why does it matter? Because the reason why I say that is, and I'm going to be really frank with everyone. I know everyone here has probably tried cases in front of me. I'm going to handle this case a little bit differently because of 212 motions. It's going to be a firm hand as far as this case is concerned. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiffs, and then we'll move to the defense.
Good morning, Your Honor. Will Kemp for plaintiffs.
Good morning, Your Honor. Eric Pepperman, also for plaintiffs.
Good morning, Your Honor. Teddy Parker on behalf of Jim Cavanaugh, plaintiff.
Good morning, Your Honor. Elizabeth Lowell from Milwaukee Instruments.
All right.
Good morning, Your Honor. Joel Odou on behalf of AffinityFiles.com, Inc. and Real Water.
Good morning, Your Honor. Scott Rasmussen on behalf of Hanna Instruments.
Good morning, Your Honor. David Spurlock on behalf of United Natural Foods.
Your Honor, Jim Neale, also on behalf of United Natural Foods.
Good morning, Your Honor. Alex
Velko
Velko on behalf of... Go ahead, Mr. Cavanaugh.
Jim Cavanaugh, Gordon Reese, on behalf of third-party defendant, Real Water, Tennessee.
Good morning, Your Honor. Alex Velko on behalf of Hanna Instruments and Milwaukee Instruments.
And ma'am, does that cover all appearances?
Yes.
Okay, once again, good morning to everyone. I see we have a couple of matters on calendar for this morning. I think we have first and foremost a couple motions to associate. Are there any oppositions to those?
No, Your Honor.
All right, I just want to make sure I'm clear. I guess one was regarding Jeremy Waltman, is that correct?
Yes, Your Honor.
Okay, we'll go ahead and grant that. And the next one was Russell N. Stein, is that correct?
Yes, Your Honor.
Okay, that'll be granted also. And let's go ahead and move to the next matter on calendar. It's my understanding we have a motion to strike defendant Milwaukee Instruments answer for violation of the special matters order in this matter. Is that correct?
Yes, Your Honor.
Okay.
We've talked to opposing counsel, and we both have agreed that it's probably better to move that to the 4 days of hearings that we have coming up rather than to take it out of order now.
Okay, and then when you talk about the 4 days of hearings, that would be
Preliminary hearings.
starting on the 24th. Is that correct?
Yes.
Is that correct, ma'am? Okay, we'll go ahead and set that for that time period. Okay. And so what is the number, Julian? How many motions do we have? 211? 211. 212 now. Okay. All right. I don't know if that's a record or not. We might have eclipsed that. I'm not sure. I have to think about it. Okay, now, I guess we go to status checks and the like, right?
That's my
Okay. And I see we have one issue that has to be resolved immediately, and that's regarding the jury questionnaire.
Yes, Your Honor. We just have the one line that Mr. Rasmussen objected to in the case description, but other than that, it's
Ready to go?
Yeah.
Okay, let's deal with that right now. And I guess the objection would be the following, quote, the plaintiffs assert claims against various defendants related to manufacture, distribution, and sale of real water, as far as the description is concerned. What's wrong with that?
Honor, Scott Rasmussen on behalf of Hanna Instruments. My company distributes an ORP meter. It has nothing to do with the manufacturing of real water at all. And so we proposed alternative language.
Is that a component?
It's a meter that measures electrical current in a solution.
You're correct, Your Honor. The meter
It's
is
a component,
used
right?
as a component to manufacture real water. Correct.
Right. Okay, they're involved in manufacturing.
Your Honor, we distribute an ORP meter. We don't do anything else. So we're not part of the manufacturing. We're not part of the distribution. We're not part of the sale of real water.
Is it a component?
In our opinion, it is not, Your Honor, since we don't.
And why does it matter? Why does it matter? Because the reason why I say that is, and I'm going to be really frank with everyone. I know everyone here has probably tried cases in front of me. I'm going to handle this case a little bit differently because of 212 motions. It's going to be a firm hand as far as this case is concerned. I'll be candid. I don't think it matters.
Words to make sure that benign language was just changed by what? 5 words, I think.
Right. But my point is this: if we're going to, if every issue is going to be like this, I'm going to be very firm.
Your Honor,
right?
we've agreed to everything. We've agreed to everything in that jury questionnaire, but that sentence.
I understand, and as far as the sentence is concerned, to me it appears to be very benign, because components are part of manufacturing, right?
But we didn't manufacture. We distributed an ORP meter.
Well, but it doesn't matter. It's a component, right?
We don't see it that way, Your Honor. But you do what you feel like you believe is the right thing to do.
Well, the right thing to do is to keep it benign, and it's very benign. There's no argument, no allegations of defects or any of those types of argumentative descriptions I've seen in the past. In fact, this is probably one of the most benign I've seen, period. So I'm going to keep it really simple. So it will be the plaintiffs assert claims against the various defendants relating to manufacture, distribution, and sale of real water. That's pretty broad. I think that covers everything. Okay. That's what it will be. So how soon can you get those two?
Your Honor, my office will send.
Drop dead date on that. We need it today, ready to go for all practical purposes.
The jury services gave us a deadline of 1,200 copies of the 7th.
Right.
As soon as we get the admonition page signed by Your Honor, we will send it at the final questionnaire out to Holo for copying, and they will have the 1,200 copies delivered to jury services by Thursday.
Do you have a copy of that page with you today?
I do, Your Honor.
Can we how are you doing, Mr. Roberts? Good to see you.
Good to see you. May I approach?
Show counsel first, just to make sure. And show it to, ma'am, want to make sure. Oh, you okay? You're together. Just don't want to overlook you, man. You're welcome. Let me see. All right, because we got to get this moving pronto. Okay, so you may approach. So that's done. Thank you, sir. Okay. So what's next? Oh, I got that. I'm going to bring it up. I can just tell you what my course of conduct has always been as far as motions and hearing motions in order. It's really this simple. Unless there's an agreement to the contrary, I just hear them as filed. That's how it is. I mean, I don't pick and choose and things like that, what I want to hear, unless the parties agree. So as far as scheduling is concerned, if there's no agreement, we just go in order. How's that?
I think we'll try to find an agreement, Your Honor. But
Yeah, I just want to tell you, I'm not going to pick and choose whose motion I'm going to hear first, right? That's not fair. And if you can come to some sort of accord or agreement on that issue, then I'll follow that. But if we don't have an agreement, we're just going to go in order as set forth on my docket right here. All 212. Right? That's what we're going to do. Okay, that's taken care of. What's next? That's all you have? Okay. All right. So where do we go from here?
On behalf of the plaintiffs, Your Honor, we don't have anything else for today.
And with the jury questionnaires taken care of, I hear the motion to strike coming up at the time. Associate counsel's been granted. Anything else you need from me?
Nothing from Milwaukee, Your Honor.
All right. Plaintiffs? Anything else? So I guess I'll next see you on the 24th, is that correct?
Yes, Your Honor.
For the record, the motion to strike will be on the 24th.
Right. Okay, I was ready to roll today, but
And Your Honor, if I may, this is Jim Neale on behalf of UNFW.
Yes.
I know there was discussion about the jury questionnaire, and I think it's clear, but just to reiterate for the record, I hope that the court will indulge me and allow me to make clear that the prior stated objections still stand to that. We understand the court's ruling and certainly aren't asking it to reconsider. But
I mean, the record stands for the record, right? And
yes, sir.
As far as the questionnaire is concerned, I think we made a vigorous record as far as those issues are concerned. And to be candid, I mean, 42A gives the court broad discretion, specifically as it relates to whether there's going to be a questionnaire, what type of voir dire will be performed, and so on. So it is what it is. And
thank you,
anyway, I got you. Anything else?
Nothing else, Your Honor.
From the defense, anything else?
Oh, Your Honor.
Okay, everyone enjoy your day.
Thank you, Your Honor.
Thank you.